Thank you. The return date hearing is in the matter of CFI 043-2022 before Justice Sir Jeremy Cooke and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Trowers and Hamlins, LLP. Lead counsel is Tom Montague Smith, QC. The defendant is represented by KBH Limited. Lead counsel is Bushra Ahmed.
Yes.
Good morning, my lord. As you'll have seen, I appear on behalf of the claimant, and that's the applicant, and my learned friend, Ms. Ahmed, appears on behalf of the defendant. This is the return date for the hearing of an application for freezing order and an injunction, and that was an order made by His Honour Robert French last Wednesday, and so this is now the return date. Your Honour, your Lordship may have seen my skeleton argument. Things have moved on a little bit since then. As you may have seen from my learned friend's argument, which has come through overnight, everybody now agrees that the substance of this hearing can go off.
Yeah.
We say that that would have been capable of agreement in advance, but our position is that the defendant simply wasn't complying, at least with some aspects of the order, up until late yesterday, and had failed to confirm that he would do so. Now, I'll take you through that in due course. But the defendant finally provided what was in effect the missing asset disclosure yesterday at 4 p.m. and confirmed that he would comply with the order. Those were the conditions on which we said we would be willing to agree to an adjournment. But that came so late it was impossible now to avoid the costs of this hearing. So there is an issue as to costs, and I'll come on to that. But now that we are here, it occurs to us that Your Honour might be able to help us with the timing of the adjourned return date. There's a minor difference between the parties as to how you structure the order precisely, but I don't think that will trouble anyone. The question really is about when we get this back on. My learned friend proposes a return date on the 17th of August, which is obviously right in the middle of what for many will be their holidays, and we won't be able to accommodate that date. And so the problem from our perspective is that if we get into August, availability means that realistically we're going to be pushed back into September. And so we were hoping that Your Honour might, or Your Lordship might be able to give us directions which would help us get on by the end of July.
Well, let me tell you at once, because that may present personal difficulties for me. I'm simply unavailable because I'm working at a children's camp between the 22nd of July and the end of July. I've got hearings on well, the only dates I could do in July, I think the 21st of July, probably.
I think what my learned friend would say about that would be that's just too soon. Right. I mean, she's asking for a date in August because she's proposing that her client serves his evidence in 3 weeks' time. So what we were hoping to do is to truncate that timetable and get us on, for the last week of July. But that's obviously subject to your availability, and if you're not available,
well, it's not necessarily subject to my availability because there may be some other judge who can do it. I mean, it's not,
Of course.
I'm coming into this day November today, so there's no reason why another judge can't come in and do the issues, whether it's jurisdictional or whatever it may be.
Yes. So I mean, we don't know what the issues are. We've been told that the issues are going to be jurisdiction, service, and the substance of the order generally, but we haven't had a list of full and frank points. So
hard to see anything much on service, but jurisdiction, I can see there may be some scope for argument.
Right. All right. Well, I think then perhaps it's looking likely that we will be pushed off into September, and therefore we just need to schedule something at that point. I mean, I take your lordship's point that some other judge may be available, but the answer is some other judge may not be available, and it probably makes sense for us to make some directions now when we know that there is availability all round. My availability is difficult for the first 3 weeks of August, and obviously it would be good to have a little bit of a lead time. But I certainly, and I think my solicitors could accommodate something from the week of the 29th of August or in the 5th of September, if that suits everyone. We'll need to schedule some evidence, and to give some time to do that. I suspect perhaps the week of the 5th of September would be the best. I haven't discussed this with my learned friend, but perhaps I could suggest that then. The week of the 5th of September.
Yeah, just bear with me. It looks as though I could do the 8th or 9th of September.
For me, the 9th is difficult because I have a Civil Procedure Rule Committee meeting that's floating in that day. It may not happen, but it may, so it's blocked out. But I could certainly do the 8th, and unless my solicitors say they can't, then that's the date that I would propose. But my learned friend hasn't had a chance.
How does that work for you, Ms. Ahmed?
Your Lordship, I think I'd probably need to take instructions. On the face of it, it appears to be a date that's doable, but obviously that's subject to taking instructions, and the availability of counsel that may need to be instructed, senior counsel, and of course the availability of my client as well. But on the face of it, it looks doable, Your Lordship.
Yes, in terms of preparation time, obviously that's fine in the timetable you've suggested. So it's just a question of finding a date. I mean, September, there are less likely to be problems finding judges too. So if there are other dates that don't work for me but work for other judges, let's work provisionally on the basis of the 8th of September, shall we?
Thank you.
Thank you.
Very good. Well, on that basis, do you want to set dates for service of evidence then? Make some suggestions.
So my learned friend has suggested that she should provide her evidence by the 27th of July. I mean, again, the difficulty is that runs straight into August for our response evidence. I think that we would be happy with that as long as we got quite a long time to respond, because I think the first 3 weeks of August are just going to be dead, unfortunately. But if we were to have until, I think the 20, I'm going to be told off if I get this wrong, but the 26th of August, I think, was what we were going to suggest for our response evidence. But I'm waiting to be correct. 26th is fine, I'm told. So 26th of August, that gives everybody a couple of weeks to prepare for the hearing.
I mean, if there are arguments on jurisdiction, they're going to be essentially legal arguments, aren't they?
Yes, but they may, or yes, and I don't suggest that there's going to be an awful lot of evidence on jurisdiction. I do suspect that there may be evidence about good arguable case. There may be arguments about full and frank disclosure. Who knows? I'm a bit reluctant to agree to a very short time scale.
No, understood.
And we don't know what the response may be. So if we did it that way, 27th of July for the response evidence, 26th of August for my evidence in reply, that there is likely to be a jurisdiction application as well. That is actually due by the 13th of July. What I might suggest is that, well, I suppose we'll just, if that were to be made on the 13th, I suppose we could just respond to it all at the same time, rather than have 2 rounds of evidence.
I would have thought so, but you know, unless there's some good reason for getting something on earlier as a distinct and discrete point, but in practice that'll be difficult to achieve. So let's do it all together.
Yeah, thank you.
Does that make sense, Ms. Ahmed? So 13th July, you've got to do your jurisdiction application in any event.
Yes.
27th July response on in relation to the freezing injunction itself and whatever points you want to take. 26th August reply to that from the claimants. 8th of September hearing.
Well, Your Lordship, there is another factor, or rather another direction. Our reply to my learned friend's response to the jurisdiction application. So we'll be making our jurisdiction application on or around the 13th. I thought it was slightly later, but I'll stand corrected. Then, of course, in response to that jurisdiction application, my learned friend will file his evidence or legal submissions, whatever it will be, and then we'll have an opportunity to reply. So I think we just have to factor in that reply evidence to my learned friend's response to the jurisdiction application.
Yes. When do you want to fit that in then?
I'm just trying to sort of work out. See, I thought that we had to file our application for jurisdiction by the 19th, but let me just work that out, because we've got 14 days from the acknowledgement of service, which was filed yesterday. 12th is 7 days, 9th. So 19th, I see.
You're right.
19th.
You're right. You're right.
Okay.
My mistake. I apologise.
No, that's okay. So 19th, and then you will, I think, have 14 days to respond to that jurisdiction application, the claimant will. So that's sort of the 2nd of August. Then
sorry to interrupt. I mean, that's what I was saying, was that it doesn't make an awful lot of sense to have multiple witness statements flying forward.
So what the effect of that is that if you deal with it all on the 26th of August, then there's got to be a further, however long it takes for any response to that on the jurisdiction. I can't myself see that there's going to be much need for witness evidence in response, but you never quite know. As I say, it's essentially going to be a question of law, isn't it?
yes, that's correct, but I can't pin my colours to the mast at this stage, having only been instructed on Monday evening. So,
but if I don't think it would be a problem if we set the 5th of September for a reply, while still maintaining the 8th of September as the hearing date.
Yes, and then obviously skeleton arguments maybe at the same time then? On the 5th of September?
That's a bit
Can
too...
Can I make a suggestion, which is this, that our evidence in answer will come on the 26th. If my learned friend was to file her any responsive evidence, as you say, it's going to be very limited. I was going to say the 1st of September, but if it's the 2nd, it doesn't make too much difference. We can all then file and exchange skeleton arguments on the 6th.
Yeah, I agree.
May I have the 3rd of September? Because I think the other thing is, and Your Lordship, as an off-piece, I'm very curious to know which children's camp you're going to be working in. Maybe I can send my 3 little ones, all under the age of 6 there.
No, this is for kids over the age of 11.
Okay.
If they're over 11, they'd be very welcome.
Yes, but putting that to one side, there are sort of holiday commitments at our end as well.
Yes,
I mean, I'm now booked to go away. Well, I was booked to go away sort of on the 18th of July and my holiday finishes on the 13th. Now, given this case, I was intending to work sort of from overseas. But so having said that, that sort of timetable will be pushed, and there will be 4 weeks where I'm out. And so in terms of the jurisdiction application, it may have an effect on the responsive evidence. And so effectively what I'm trying to say is that if we could have 7 days perhaps to consider whether or not we can, or we should file responsive evidence, because I think the 3rd of September also falls on a Sunday, if I'm not mistaken.
Saturday.
No, sorry. So the proposal is that you will have 7 days from the 26th, Friday the 26th.
Yes, but
I think you to Friday the 2nd, Saturday is the 3rd. I say if we leave it to the 5th, it's the Monday. That's the issue, isn't it? Yeah. And if we're sitting on the Thursday, it doesn't give really much scope to adjust. My thinking is that in reality, the jurisdiction application, there won't be much evidence beyond what you put in the first place.
Well, Your Lordship, I'm going to make some submissions about that, just because I think one of the, I'm not going to go as far as saying complaints by my learned friend, but one of the points that he's made is that they don't know what issues might be flagged up on any return date. So I think maybe it might be just fair to my learned friend and to the court perhaps to sort of highlight and give the court a flavour of the sorts of issues that we intend to flag up. and that will sort of involve issues in relation to jurisdiction and potential arguments in relation to jurisdiction.
Well, do you want to outline them now? That would be helpful.
Yes, of course. Your Lordship, I mean, I don't know how much you have read in terms of the affidavits that have been filed, but essentially this claim arises out of an embittered relationship, if I can call that, between a father and son. And of course, I don't expect the court to go into the rights and wrongs of the merits of the case and all the relationships, but Your Lordship, and this perhaps influences and impacts on my submissions in relation to costs as well. What we would invite the court to do is to be mindful of, one, that the parties are placed on an equal footing. And in that respect, my Lordship, and maybe again I'm going off tangent, but it will all sort of, this all kind of relates to the cost submissions that my learned friend is probably unlikely to make as well, because he's flagged up as that being one of the issues. Your Lordship, in terms of putting the parties on an equal footing, one of the points that were raised by my learned friend in his application before His Honour Judge French was 2 points, one of jurisdiction and one of full and frank disclosure. And your Lordship, whilst keeping our sort of powder dry, because we've only had the opportunity of speaking to the defendant for about 4 hours, I just want to take you on those 2 points to my learned friend's first skeleton argument. I don't know if you have that there.
Yeah, you can take it. I've read the skeletons, and although I didn't read in detail all of the affidavit in support of the application for the freezing injunction, I've read enough of it in the light of the skeletons to see the litigation that's going on elsewhere and so on and so forth. You know, I have all of that pretty clearly in mind.
Yes, Your Lordship, and one of the points that was raised is the question of the DIFC courts having a freestanding jurisdiction to grant injunctions in aid of proceedings. And one of the issues that were raised was whether or not there is any debate about the DIFC exercising an exorbitant jurisdiction for 2 reasons. And in that context, Your Lordship, I refer to the transcript that my learned friend's lawyers transcribed of the hearing, and that's attached to my skeleton argument. I don't know if you have a copy there.
Well, I can. It's not filed on CMS yet, is it?
It's not in the bundle. I didn't see it in the bundle, and I flagged it at the start of our skeleton argument. So we attached it to our skeleton argument this morning.
Yeah, just bear with me, because I need to get it on an attachment to the email. Okay, I've got the appendix to your skeleton in front of me now, yeah.
Yes, and one of the appendices should include, one of the appendixes is the transcript.
Yep.
And I'd invite Your Lordship to turn to page 3 of the transcript.
Yes.
And this was a discussion about whether or not the DIFC court has the jurisdiction to make a freestanding injunction order. And the learned judge, sort of halfway down the page, 1, 2, 3, 4 entries up from the bottom, I don't think I'm prepared to make a freezing order in respect of a prospective claim. And at that point in time, the argument was that there was going to be a prospective claim in the Dubai courts for some sort of a loan or monies that was said allegedly taken by the defendant. And my learned friend said, there's no problem in principle with doing that. That way in which Convoy Collateral Limited against Broad Idea, and that's the BVI case that dealt with this sort of black swan jurisdiction of making injunctions, granting injunctions, explain things. And this has been adopted by the DIFC in the Latif case, is to say that one only needs a good arguable case that there will be an enforceable judgment at some stage. And the judge therefore then asks His Honour Judge French, what is the basis for the misappropriation? What is the evidential basis for it? I note there is an investigative report in relation to the respondent misdeeds, which are merely allegations and then a termination, but I wouldn't necessarily regard that as evidence supporting the granting of anything. And then my learned friend responds, what we have is the evidence of Allan Jones saying that there has been an investigation and this is what has been found, have been missing from the company, and this is why. We go over the page. And I just want to take you to this point because the last entry that I invited you to read and this entry now also goes towards whether or not there is an arguable case and a serious issue to be tried point. So page 4, 1, 2, 3, 4, 5 entries up. The judge said, I had not come across that I had gone into detail regarding the employment investigation report. However, I would not find that there is a seriously arguable case on the basis of that sort of speculation. My learned friend responds, I understand. I would not, however, characterise it as speculation, but rather an updating of the report. Learned judge responds, an extrapolation of the report. And then my learned friend turns and says, well, this is what has been found to date. This is, I accept there is no detail there, but this is not speculation, etc., etc. We then, Your Lordship, go to page 5 of the transcript. And these two entries that I'm going to read out refer again to the jurisdiction issue. First, second, third, fourth, fifth entry down, Judge. I can give you some preliminary indications if that would help. These are though just preliminary. I have been through the order. Additionally, there may be a debate about jurisdiction. I don't think we've had a case yet where a freezing order has been granted in support of a pending proceeding in another court. Perhaps you can point me to one. My learned friend then responds, that was the Latif case, albeit that was in support of an arbitration. Okay, anyway, there is a potential argument about jurisdiction. So the way I would frame it is in terms of the Credit Suisse case, where the DIFC court said that in an ex parte proceeding where there is a possible debate about jurisdiction, the court would leave open the possibility of a challenge to jurisdiction and the associated powers to make that order. The court is exercising preliminary jurisdiction. This is what the Court of Appeal did in the Credit Suisse case. So any order must be framed saying the right of respondent to challenge the jurisdiction. So, Your Lordship, I'm grateful for indulging me in reading those sections out. But the first point is in terms of the points that are likely to be raised is, number one, the jurisdiction of the DIFC court in terms of making this freestanding injunction where there is no pending. We say no pending claim, firstly. Secondly, the debate about whether or not in the context of Dubai court proceedings, not necessarily in arbitration, but in the context of Dubai court proceedings, where you have an interplay of the conflict of jurisdiction arising out of, let's say, the JJC procedures, whether or not in the context of that interplay, the DIFC courts can grant a freestanding freezing injunction of this nature. And those are the sort of preliminary areas of exploration that we are undertaking at this stage. Now, I'm not saying that those are definitive, but these are the sorts of inquiries that we will be making in terms of jurisdiction arising out of, number one, the Latif case, or the orders that were granted as a result of the Latif case, the judge's inquiries made it to my learned friend, and of course, really the exploration of how the interplay between the DIFC courts and the Dubai courts work in the context of proceedings, a number of proceedings which are on foot in the Dubai courts. So that's the first point in terms of jurisdiction. Now, the other point that we are likely to raise again is whether or not there is an arguable case, whether or not there is a serious issue to be tried, and of course the merits of granting the freezing injunction. And I've referred you to various aspects of the transcript. I don't intend to go into any detail in relation to the evidence that was filed before the court, but that's the sort of second point to be made. And again, just as an aside, the claimant has attempted to paint a picture in relation to the claimant that this is somebody who is, well, he's the son that's come along and attempted to seize assets belonging to his father. And I'm instructed to make this submission to the court on behalf of the defendant that his position is that that's actually not the case. His position is that he was induced to come over from the UK many years ago by his father to try and run a business on the promise that he would have a share in the business. Where the claimant is asserting a trust over these assets, the defendant's position is, in fact, that these were gifted to him. And his position, his third position is that...
Well, none of this is a matter for today. I understand all this is going to be hotly disputed. But to revert to your earlier point, isn't the position this? There are two current sets of proceedings in onshore Dubai. The issue you raise in relation to pending proceedings only relates to the claim by the third claimant. Have I got that right?
Yes.
Yes. Okay. So in reality, I'm not going to say that's a small part of the dispute, but you know, the jurisdiction application has to be a root and branch one that says, well, you simply can't do this in support of Dubai proceedings. The court shouldn't be allowed to do that.
Well,
and that's the basic point, isn't it?
Yes, and my lordship, I'm going to turn to that point as well in the context of a full and frank disclosure point. And the reason why I raise it in the context of full and frank disclosure, because in my learned friend's skeleton argument, right at the end, under a heading, and I think it's section H, if I've got the correct skeleton argument, I've put it somewhere, here it is. There's a section in my learned friend's skeleton argument which deals with full and frank disclosure, and it's section H. And at paragraph 83, in this section, my learned friend says, well, it may be said that the DIFC court should not intervene as the disputes are before the Dubai courts. The order is sought in support of the Dubai court claims. Claimants are not attempting to have their disputes resolved in the DIFC courts, or obtain an interim relief is likely to be procedurally difficult at this stage of the Dubai court proceedings. DIFC courts have acknowledged that in appropriate cases and will support foreign court proceedings, Latif, and Dubai seated arbitration proceedings, Brookfield, Multiplex. Now, in that context, the debate that was raised or the issues that were discussed at the hearing, again, if your lordship may invite you to turn back to the transcript.
Yeah.
And page 1 is on a Judge French at the bottom of that first box, asks the question, my first question, and I shall raise issues of jurisdiction later, is that you have 2 proceedings ongoing in the onshore courts and a 3rd proceeding promised. Is it not possible to get orders relevant to those proceedings in the onshore courts of Dubai? And my learned friend's response was, in principle, it might be possible. One might be able to take several different actions in the Dubai courts. However, we only get to make this application once. Once we make this application, the respondent knows about it. It is likely the case that the same sort of relief is difficult or impossible to obtain where there is a dispute. Once you have an acknowledged debt or court judgment, that one may be able to get an attachment order. However, in the civil legal system, there is no equivalent to the in personam freezing order. And then the judge asks, is there a statutory equivalent? My learned friend responds, there is a concept of attachment over properties. However, it is not a clear shot and can be a difficult application. Such an application would likely need to be obtained in multiple ways through multiple applications. This would likely take time. And then my learned friend, I'm going to just jump to his next entry, leaving aside what the judge said. There are a variety of ways this could end up, and an order could be framed. Jumping down halfway down to that box, but there is no such thing as equity in Dubai. In a jurisdiction where there is no concept of equity, you may reach the conclusion that the property is held by the respondent as a nominee for the first claimant, or alternatively, it may be interpreted on the basis that there exists a binding agreement. One does not need more than a binding agreement under UAE law, that certain things will be done, and then the debate continues. In our preliminary inquiries, Your Lordship, and I don't think I'm giving anything away by saying this, but in our preliminary inquiries, it appears, and again I say these inquiries are preliminary, it appears that that might not be the case, and therefore that's something that would need to be explored. Now, if that's right, then there are 2 options available to us. Number 1, either we obtain an expert report and put it before the judge, or the judge can consider foreign law as a matter of fact and submissions can be made. I mean, at the moment, that's something that hasn't been determined in terms of what would be the best way. I mean, it may be, Your Lordship, you may have a preferred approach, and obviously we would be happy to follow that. But again, there's been very limited time in which all of these instructions can be taken and all of this can be bottomed out. And so, Your Lordship, those really are the kind of 3 points that are likely to be framed at any return date hearing.
Yes. I don't think that changes my view much as to the fact that whatever you do has got to essentially all appear in your first lot of material, and there won't be a great deal by way of reply. obviously, if there are issues of onshore Dubai law, you may want to put all that in an affidavit from an onshore Dubai lawyer, which I think in an area like this would be my preference, rather than having it simply argued as a matter of submission. But I can't, at the end of the day, think there's likely to be a huge element of dispute about both what the statutes say, the concept of trust as being unknown, as I understand it, and then what you can and can't do in terms of getting interim relief of one kind or another in the onshore Dubai courts. So I should have thought those could be covered in the evidence that you adduced first, and then Mr. Montague-Smith's clients adduce in response. And
my fear is sometimes it happens that there are two diametrically opposed views.
well, I know, but one would have thought in an area such as this,
I appreciate.
harder to achieve, but you never know.
Yes, no, understood, and thank you, and especially thank you for the guidance in terms of how that evidence ought to be presented before the court.
So I think we can work on the basis. I think we have to work on the basis of the 2nd of September in reality for your response, which is the Friday, and the 8th of September for the hearing date. Yeah.
Your Lordship, in terms of the 8th of September, again, can we provisionally set that down as a date, subject to taking senior counsel's availability as well?
Yeah.
I'm grateful, thank you.
Well, there's liberty to apply, but we're all going to work on that basis, and you will have gathered from the discussion it's not going to be terribly easy to find alternatives.
Yes.
You shouldn't have a difficulty in finding a leading counsel. I mean, August is always the problem.
Yes.
With leading counsel, September is usually okay. All right. So that sorts the timetable out. Does that simply leave the vexed question of costs?
Yes,
I beg your pardon. I'm sorry, Mr. Tom Montague-Smith. There was an issue in terms of the form of the order, because we had suggested a particular form, and namely that the form of the order should take the return date as being adjourned, and for the parties to come back, and then my learned friend argues for the continuation of the injunction. Now, as I understand, my learned friend wanted a continuation.
This is just a matter of verbiage, isn't it? Because the injunction is going to continue until the matter is further debated. So, I mean, it really isn't very significant whether it's talked, quite how it's framed, as long as it's clear that it is going to continue, and that it's still open to you to raise jurisdiction and the other points you want to raise on a further hearing date.
Yes, and that we don't need to make a separate application to set aside the injunction.
No,
exactly, yes.
It's neither here nor there. It's just an extra bit of cost, isn't it, if you have to make an application? But no, I don't need you to do that.
Grateful, thank you.
No, I think we made clear that we didn't take any points on that. So I don't think I hope we won't have any trouble putting an order together in relation to that. My Lord, in relation to, you've heard quite a lot about the hearing. I mean, quite a bit of what you've heard is not accurate, but there we are.
Well, I appreciate it's all hotly disputed. I can see that.
Well, yeah. I mean, I just emphasise the point that quite a lot of what you've heard about what happened at the hearing is not quite accurate either. So, never mind. I'll leave it there. I mean, for example, you'll note that the bit about the claim that hasn't been made yet accounts for 155,000 dirhams of the total 3 million freezing order.
No, I realise that.
Yeah, good. All right. Well, then there's just the issue of today's costs. And what I'd say is this. As soon as we were asked to adjourn this hearing, we said that we would be willing to do so, but we weren't prepared to do that, to agree to that, when the defendant was in breach of the order, in breach of the obligations to provide disclosure about assets, and when he was at that stage it was unclear whether he was going to comply, and he was refusing to say whether he was going to comply. And what I wanted to do is just, if I may, I'm going to have to take you through a very little bit of correspondence on this.
Well, I read the clip of correspondence
Grateful.
up to, I think, what would have been close of play yesterday, probably.
Well, if that might include the 4 p.m. letter,
yes,
from my learned friends,
that's the one where their disclosure was given of the Lamborghini, the Bentley, and the 2 villas.
There's been a subsequent letter overnight which does shed a little bit of light on things. Amongst other things, it makes clear that KBH were contacted on Friday last week, and that they spent time with the claimant, the defendant, and discussed the order with him on Sunday.
Yeah.
So that by Sunday, he's got legal advice. Now, just to take you through the chronology, you'll remember this then, and I won't necessarily need to show you the documentation. You have the order is served on Wednesday evening. There's a chasing letter on Thursday, and then on Friday there's a response. And this is the one that my learned friend relies on, where he says he's seeking legal assistance, but that he says in that he would comply. But then 2 hours later, you get that subsequent email where he says, well, any subsequent compliance, will be subject to obtaining legal advice, which he claimed he was unable to do. So that's on Friday. And then, of course, there's a debate about whether he's got until Saturday or Sunday to do it, because he talks about the deeming provisions, but he misses that deadline anyway, so that's all a big waste of time. Now, the specific obligation was to provide disclosure of his assets over $100,000. And when he's provided that disclosure, he's produced a list of 4 assets. So it's not an onerous obligation. This is not the detailed one that I'll have to do shortly. And 3 of those assets are 3 of the assets that are in dispute. And one of them is one that we already knew about. So what we're trying to find, obviously, is big lumps of cash or big assets that we're not aware of, and there aren't any. So he could have complied at that point. And obviously we disagreed about whether it was Saturday or Sunday, but we said, look, fine, take until Sunday, but give us the information. But again, I mean, that became rather arid because he missed that deadline. But what that episode demonstrates, we says that he plainly had access to legal advice at that point. He had his Dubai lawyers who have a DIFC capability. Now, it's said that they're not experts in injunctions, but they are listed, as we understand it, registered practitioners in the DIFC. That's HLP who are acting. And obviously he chose not to use them, but he has been in contact with KBH Canaan since Friday. But either way, he wasn't coming to this dispute fresh to disputes in Dubai. He had a starting point from which to find a lawyer. And we said it beggars belief that he wasn't able to get legal advice to the effect that he needs to comply with this order. And we say that he should have complied anyway. And I put it like this. I mean, one can see there might be arguments about whether or not the right court to order him around is this court or the Dubai courts. But if I'm a foreign person living in, say, the south of France, and I get an order from the Paris court telling me to do something, my response isn't, well, perhaps it's not up to the Paris court. My response should be, yes, I will do what I am told when it comes from an order from an appropriate court. But I think, it could have been resolved on Monday, because when KBH are appointed, they write a letter and it just says nothing whatsoever about compliance. They simply ask for an adjournment and make various complaints about the tone of correspondence. And then in response, very shortly afterwards, the claimant solicitors point out that the defendant's in breach of the order, and they set out in precise terms what will satisfy them. And they say they need assurances, amongst other things, that the asset disclosure will come within 24 hours. They're not actually requiring sort of instantaneous compliance. They're just saying, look, give us some assurance that you are actually going to comply. Because there were clear concerns about that the defendant if he wasn't complying with that aspect, he wasn't going to comply with the order. And then, so that's all that was requested on Monday evening, or early morning of Tuesday. And the answer again comes back, and that is equally extraordinary. You may have seen this. This is on Tuesday morning. It does not provide those assurances. It simply doesn't. And all that needed to be said at that point was, yes, we will give you that information within 24 hours. Yes, my client wishes to comply. But instead it said, well, we haven't had a chance to discuss this with our client because we spent all morning writing an answer to your letter, which is an astonishing response. And it didn't provide the confirmation. It just said, well, we'll tell you by 4 p.m. And of course, we couldn't wait until 4 p.m. before I put together a skeleton argument. And obviously, my brief fee was incurred quite late. We agreed a late incurring a brief fee, which was 9 a.m. UK time yesterday, noon Dubai. And so really that is what's triggered the incurring of costs for today. If we'd got that confirmation very quickly saying, yes, he will comply, then we could have avoided all of this. I mean, and I just make the point that even now, my learned friend's correspondent says, no, the defendant hasn't breached the order. Quite how that is a defensible position is very difficult to understand. Now, we say a certain amount of information is still missing, but in substance he's complied. Now that we have the assurances that we have been given, we were immediately content for the substance of this to be put off. But we do say that the defendant should pay the costs of today because they could have been avoided by a reasonable and sensible approach at any stage. First, the defendant could have just complied. Second, having spoken to solicitors on Friday, or at least on Sunday, as we know that he did, you would expect the first thing that they would say is, well, we can have an argument about the order, but the first thing you need to do is make sure you've complied. Have you complied? And he's obviously been getting assistance with emails along the way. But at best, we say between Sunday and Tuesday, the impression is he's just deciding whether he's going to comply. So really, the whole situation could have been salvaged on Monday when KVH came on the scene, and they should really have been on behalf of their client saying, look, here's the information that's required. And yes, of course, he's going to comply going forwards. But instead, they took the time to write twice without giving those assurances. So the result is that about $28,000 worth of costs have been thrown away with having to trouble your lordship with today. So what I say is that the bottom line is if you are in breach of a freezing order, as the defendant undoubtedly was, you can't simply expect to be given an adjournment. And if you don't rectify that breach until 4 p.m. on the day before the hearing, you're going to cause quite a lot of costs to be thrown away. So that's what I say on costs.
Yes. Yeah.
Yes, Your Lordship. First of all, we say that the defendant conducted himself reasonably and sensibly in the context of what he was having to deal with first. Second, Your Lordship, just because a defendant to a freezing order contacts solicitors doesn't necessarily mean that that is legal advice or legal instruction. No solicitor or no lawyer would ever give any legal advice unless that is covered by a retainer, and that retainer only comes into effect when somebody is onboarded, or rather a client is onboarded. And Your Lordship, if I may perhaps just take you through the correspondence, because if the issue is one of cost, then it was beholden to my learned friends at solicitors who have actually indicated that there was going to be a cost issue involved, and that cost issue was only raised very, very late in the day when my learned friend received the letter from KVH and I think that was raised on the 5th of July, first thing in the morning. But Your Lordship, may I just perhaps trouble you and take you through the correspondence just to demonstrate how all of this is actually in fact played out. Your Lordship, on the 29th of June, and the first letter is G12 to G16 of the return date hearing bundle. This is the letter that was written serving the order and the various documents. Now, Your Lordship, I'm not going to trouble you and take you through the whole of the letter, but if you turn to paragraph 10.
So which exhibit are you taking me to now?
G12 to G16 of the hearing bundle, the return date hearing bundle.
G12. Yeah, well, I'm on G12, yeah.
G12, that's the first page of the letter. And I'm looking at page 5 of the letter, G12, 13, 14, 15, G16. I'm working off a separate clip, so.
Okay.
So paragraph 10, that simply informs the defendant about whether or not he wishes to participate, and if you're unable to attend the return date, the dates in the next week on which you could attend a return date are inquired about. We then turn to the end of the letter. It talks about the penal notice, compliance. However, there is nothing there about costs, and so it wouldn't have been obvious to the defendant that there was a cost issue involved here. We then go to the second letter that was written by my learned friend's solicitors, G24. And it's G26, which is again the last page of the letter. It reiterates its request about providing dates in the coming week. Paragraph 11, the defendant's failure to respond to our letters and to comply with the order will be drawn to the DIFC court's attention. There is nothing there to say, well, and if you don't comply, then there is an issue of cost and we'll be seeking costs against you. On the 1st of July, the defendant responds. This is at G28 of the bundle. And the last sentence there states, I confirm that I am complying with the order and will respond on Monday, the 4th of July, once I have received appropriate legal advice. Now, pausing there a second, my learned friend has said that the defendant had legal advice at that point. That's not actually accurate or true, because he had a firm of solicitors, albeit registered in the DIFC, however, had no practice or experience of freezing orders, and therefore they were not instructed in respect of this matter, nor did they advise our client in respect of this matter. Secondly, in terms of the contact with KBH, it is correct to say that the defendant reached out to KBH, reached out to me. However, Your Lordship, I had a minor operation at that point and I was recovering, and I said, look, I can't speak to you today. Send me whatever you have, and maybe I can speak to you on Sunday. A file was sent over to KBH which the IT person downloaded. However, that wasn't accessed, and there was a 30-minute phone conversation in terms of a freezing order had been made, and this is obviously without waiving privilege. The defendant was instructed to come to KBH's offices on Monday morning, wherein there would be a full discussion. At that point in time, Your Lordship, the defendant was onboarded, and as soon as he was onboarded, KBH wrote a letter later on that evening. Now, coming back to the defendant's position here, the defendant, as I understand, wasn't only speaking to KBH, but he was also speaking to other lawyers at that point as well. And as I understand, there was advice given, or there was conversations had about jurisdiction and about not doing anything inconsistent with challenging jurisdiction, which is the reason why these are the various emails that you see in the bundle were sent. Notwithstanding that, Your Lordship, on the 1st of July, the defendant did in fact tell the claimant that he was complying with the order. On Monday, 4th of July, and that's G52, Your Lordship, once the claimant had been onboarded, a letter was written by KBH, and Your Lordship, I'd invite you to open that letter, in which paragraph 3, Trowers was informed that KBH had recently been instructed, was informed that the defendant's emails had indicated he needed time to take legal advice. And the first time the issue of costs was mentioned between the parties was at G54, the end of paragraph 5, wherein KBH says the tenor and tone of that letter was wholly inappropriate means of addressing a litigant in person who had sensibly indicated his intention to obtain legal advice. We reserve our client's rights in relation to the cost of this line of correspondence. And again, the point made is this: just because there is contact with a law firm doesn't necessarily mean that instructions have been given or advice has been taken. A further letter was written on by Trowers, and that's at G57. And whilst that letter is dated the 4th of July, it was in fact sent in the early hours of the 5th of July. It was sent at 12:10 a.m. And therefore, that was received by KBH, and KBH's hours are 9 to 6. And in that letter, Trowers asked for various confirmations, and those can be seen, those requests can be seen at paragraph 8, that's G59. And 8.1 requests the disclosure required by paragraph 8.1 of the order is provided, or that you confirm by 11 a.m. Dubai time that it will be provided within 24 hours. So what that is seeking by 11 a.m. either to provide the information or confirm that you're going to provide it within 24 hours. And then 8.2, confirm where the money is coming from for legal advice and living expenses. Confirm by 11 o'clock whether or not your client has complied with the order. 8.4, confirm by 11 o'clock whether or not your client has withdrawn the Lamborghini, the sale of the Lamborghini. And confirm whether or not your client will comply with the further disclosure obligations. So that was at 9 o'clock rather when that was seen. And within, and if I can then take you to G63, within 2 business hours of receiving that letter, Your Lordship, because a response was sent at 10:44, the letter of response is G66. At paragraph 3, KBH states, your points will be addressed more fully later. Further, it is likely that certain of these issues will be resolved later today and before the anticipated return date. And so that's an indication to Trowers that we would be dealing with this later today. Paragraph 4, we were instructed late yesterday and are due to meet with the defendant this morning. The meeting has been delayed as time had to be taken up this morning in responding to your lengthy letter, which seeks to unilaterally impose 11 a.m. today for a response. This is wholly unrealistic and an unreasonable deadline in respect of the fundamental issues as described by you in your letter arising out of the order. And paragraph 5, we indicate to Trowers that the claimant has, rather the defendant has sent an email Friday the 1st of June at 6:38, whereby he confirms that he is complying with the order. And then paragraph 6, we note your willingness to agree to adjournment subject to the defendant providing his confirmation on various matters. As mentioned above, we are meeting with the client this morning and will be taking his instructions to the various points raised by your letter. As such, we are likely to be in a position to respond to your letter by 4 p.m. Paragraph 7, in light of our letter dated the 4th of July, informing you that the hearing is unlikely to be an effective return date, and given our reasonable request today for more time to respond to your letter, if your client insists on incurring counsel's brief fee, then that is a matter for him. Pausing there a second, my learned friend says quite altruistically that the brief fee was only incurred at 4 o'clock, rather at 12 o'clock. Notwithstanding that, Your Lordship, this is senior counsel who's been briefed to attend the return date, who had the benefit of attending the first interim injunction ex parte hearing. In terms of incurring the brief fee, there would not have been much to do in terms of attending today, given my learned friend's experience in these matters, given his involvement in these matters, and given that the skeleton argument was really a reiteration of what had been set out in the first skeleton argument, as well as an update in terms of matters. And therefore, it was not unreasonable on behalf of the defendant to make a request that the claimant holds off incurring any fees until 4 p.m, until it had a proper opportunity to advise the client, to take instructions and to be able to draft a response within very limited, in a short space of time. And we said that that was completely reasonable under the circumstances. Your Lordship, then KBH receives a second letter that was at 12:10, and that's at G72. And Your Lordship, my learned friend's instructing solicitor say at paragraph 8 of that letter, that's at G72, 5th of July letter, Given your and his refusal to engage with our questions on this point and give a basic level of insurance, and the point is that the information that was being sought, and that's just not correct, Your Lordship, because both the defendant and KBH were engaging with this matter. They were simply seeking more time, and it wasn't more time going into hours. It was more time in terms of half a day, and that was a reasonable request, Your Lordship, to make under the circumstances. Paragraph 9 talks about it's obvious that there will be significant costs thrown away. Well, Your Lordship, I've taken you to those initial letters that were written to the defendant. It wasn't obvious there that there might be an issue of costs. The cost was raised by the first time by KBH, and it was only raised by the defendant in their letter of the 5th of July, which was sent at 12:10 a.m. And therefore, it wouldn't have been obvious to the defendant in those earlier letters that he had received that there might be an issue of costs. Your Lordship, then at 15:42, which was around 15 minutes before the 4 p.m. deadline that KBH had imposed on itself, it wrote a letter, and that's at G108, Your Lordship, containing the defendant's responses. And Your Lordship, at paragraph 2, it refers to the meeting with the defendant. It states that we intended to respond to the various points raised in your letter following that meeting, and this letter contains the defendant's responses. Paragraph 3, we say that in light of the severe penal consequences arising from the order, the defendant was entitled to seek legal representation and obtain legal advice in relation to the order. Paragraph 4, the defendant is and has been complying with the terms of the order. It was the defendant's intention to provide the information sought at paragraph 8 of your 4th of July letter following this morning's meeting, and in any event by 4 p.m. today. That intention would have been obvious from the last sentence of paragraph 3 of our first letter of the 5th of July, as well as paragraph 6. Paragraph 5 of that letter then gives the information that's been sought. 6 gives the information that's being sought. 7 gives the information in relation to the funding, or rather the living expenses and where that money is coming from. Paragraph 9 confirms that the sale of the Lamborghini has been withdrawn, and also that the villa that was up for sale is no longer on Property Finder. And paragraph 10 indicates that the defendant agrees to comply with his disclosure obligations, subject to being allowed more time given the Eid holidays. And Your Lordship, you may be aware that Eid holidays are coming up to commence on Friday, this Friday to Monday. And therefore, a couple of more days, business days, was sought to provide that information given the Eid holidays. 11, we should circulate a consent order shortly. And then paragraph 12 referred to the lawyers that Malena Friend says were in play and could have advised the defendant, and there's an explanation as to why they weren't able to. And paragraph 13, there's confirmation that the defendant did engage with the order. As foreshadowed in our first letter of the 5th of July, we anticipated that the issues you had raised would be resolved before the anticipated return date. Upon meeting with the defendant this morning, despite your request for a response within 24 hours, we are now providing an immediate response which satisfactorily addresses the matters raised in your 4th of July letter. And that goes back to the point that by 11 a.m. there was a request that either you say that you are going to provide a response or provide the response within 24 hours, and we say that we have immediately satisfied that request. Your Lordship, then there is the third letter, or rather minutes later at around 4 p.m. So our letter confirming or providing the confirmation sought was provided at around 3:42. Around 3:47, the claimant served their skeleton argument. And then at around 5:15, KBH writes a third letter, that's at G111. And at that point, we again request that that the claimants agree to an adjournment. Paragraph 6 refers to the form of the order. And at paragraph 7, in the usual way, it would be appropriate for the cost of your client's application, including the cost of the hearing, being reserved to be considered by the court at the adjourned return date. In response, Trower's writes on the 5th of July, Your Lordship, this isn't in the bundle, but I think it's attached to my skeleton argument. I wonder if you've had an opportunity to review that. That's the letter of the 5th of July, entitled The Second Letter.
Yes.
Letter written by Trower's, grateful. And the position they take, amongst other things, is in relation to the information that's been provided. They take a position in relation to HML, Yamalova and Cooke, the Dubai court lawyers. And then they deal with the various directions to be agreed. And of course, then at the end of that letter, they say 4.2, we've addressed the points raised about adjournment. And the 4.2a is whether there should be some time limit on your client's response. And they say that it should be 14 days. Costs, our position is that your client should pay the cost of the hearing with balance reserve. And Your Lordship, then I invite you to turn to the 4th letter that was written late last night. And paragraph 2, Your Lordship, do you have that before you?
I'm trying to locate it.
It's attached to our skeleton argument.
Right. Go on.
So paragraph 3 and 4 deal with the form of the order, which I don't need to take you to. Paragraph 5 deals with the reiteration of the request to allow more days because of the Eid holiday to provide the full affidavit of information. And then paragraph 9 deals with the issue of costs, or rather paragraph 8. The defendant does not agree that he should pay the cost of the hearing with only the balance to be reserved. The usual order is for all the costs to be reserved to the later return date. If your clients wish to argue that their cost of the hearing tomorrow should be subject to a different order than that made at the return date, they can raise that before the court. At the return date, should your client not agree to that approach, the defendant will incur unnecessary costs of attending the hearing tomorrow. To address the issue of costs, the defendant's right to seek to recover his costs of doing so are expressly reserved. In any event, the defendant is not and should not be held liable for the cost of the hearing in circumstances where he confirmed on the 1st of July that he was complying with the order. Whilst it is correct to state the defendant's later email on the 1st of July stated that his compliance will be subject to any legal advice obtained, your position at paragraph 4.1a of your second letter is that no doubt the first step of his legal advisors would be to advise him that he needed to comply with the order. In those circumstances, there is no basis to suggest that the defendant was not or would not comply with the order, such that your client could not agree to the adjournment sought in our letter of the 4th of July. You raised queries by a letter sent at 12:19 a.m. and we indicated in our first letter of the 5th of July, sent within 2 business days of receipt of that, business hours of receipt of that letter, that the issue raised therein would be resolved by 4 p.m. today, i.e. within 5 hours following our meeting with the defendant. Having indicated that your clients would agree to the adjournment of the hearing on the provision of various information, the defendant then provided that information in our second letter sent at 3:42, as foreshadowed in our first letter. Having taken instructions from the defendant, we promptly confirmed in terms that the order was being and would be complied with. The cost of the hearing needed occurred in these circumstances. So, Your Lordship, just to summarise all of that then, we say that in these circumstances, the claimant ought not to be entitled to its costs. The first point is this, that Your Lordship, within 2 hours of receiving the letter on Tuesday morning, business hours of receiving the letter, KBH responded and confirmed with the claimant that it would intended to respond to the request sought. Second, prior to the 4 p.m. deadline that was imposed by KBH itself, it did in fact provide those confirmations. It was reasonable on behalf of the defendant, the defendant's conduct in wanting to seek legal advice and legal representation before understanding the effects of the order, the issues in relation to jurisdiction, wasn't unreasonable. And it wasn't unreasonable that KBH wanted to meet with its client and take full instructions before providing those confirmations sought. And Your Lordship, just in terms of principle as well, even if this was the first effective return date, which it's not, because it's effectively seeking an adjournment in accordance with the ruling of His Honour Judge French, he stated in his ruling that any return date should be listed in accordance with council's availability. And that was really the tenor of all the correspondence before KBH was on record. So even if this was an effective return date, which it's not, then the costs in any event would be reserved to a date when the injunction or the continuation of the injunction would be decided in full. We are not at that stage yet, Your Lordship, and therefore we say, just a matter of principle, there's no basis now for the claimants to attempt to get some sort of a leg up and obtain costs at this early interim stage, because we say that any attempt of trying to dress up the defendant's conduct as being unreasonable is just simply not there. Within 24 hours of being instructed, KBH provided the confirmation sought. There's nothing unreasonable in that. And whilst my learned friend seeks to use hyperbole in terms of concerning and disappointing and astonishing, I think was the word used, there is nothing astonishing in the context of a defendant receiving an order made by the court with very harsh penal consequences in a situation where there is an embittered family relationship, in a situation where, Your Lordship, he has no disposable income. He was terminated by the claimant on the 9th of March. Of course, the defendant says that that was on the 26th of April, but that's not true. So since the 9th of March, he has no income. And he has obviously had to deal with all of that side of things as well in terms of trying to obtain legal representation. And so, Your Lordship, we say that there is nothing unreasonable in the conduct of either KBH or the defendant. If anything, in terms of, and this goes back to the point that I made at the beginning, the parties, the court ought to make orders wherein the parties are on an equal footing. The claimant here obviously has deep pockets. He has a whole host of lawyers, a team of lawyers constituted of senior counsel. We have 2 partners working on the case. We have 1 senior associate, 1 paralegal. And Your Lordship, trying to squeeze the defendant in this manner by writing multiple letters consisting of at least 5 or 6 pages ought not to be encouraged, we say, by the court in circumstances where the defendant is in straitened circumstances. He simply doesn't have any income, and to award an order of costs against him in these circumstances is, we say, arguably abusive, but it would have the effect of stifling him in terms of bringing forward his representation and a defence to an order which is very oppressive and very onerous, and therefore we would invite the court to guard against making any application, or rather any award for costs in these circumstances. And Your Honour, the claimants are attempting to hold the defendant to ransom, and you've seen the nature of the correspondence. His assets are frozen. He's having to beg and borrow. He has no income. He's relying on the sale of his watches in circumstances where he has a family to support. He has child maintenance. He has maintenance obligations for his mother. He has living expenses in Dubai, and now he has to afford legal representation, not only defending the various proceedings in the Dubai courts, but also the DIFC case as well, and this case as well. And therefore, we say in the first, we say that actually the claimants ought to pay our reasonable costs for their unreasonable conduct in pursuing this and prosecuting this in the unreasonable way that they have. However, if the court is not mindful to give the defendant his costs thrown away up to today, because whilst my learned friend has dressed up this hearing as something where the court had to intervene to give directions, to sort out a listing, to agree an adjournment, we say that that's actually quite disingenuous, because all of these matters would have been capable for agreement. We reached out to the claimant seeking an adjournment. We reached out to the claimant inviting them to agree directions. We reached out to them saying that we would circulate a consent order. There is no reason why 2 law firms like Trowse and Hamlin and KBH were not capable of agreeing an order of this nature. We say that they were, had it not been for the flip-flop of the claimant, where in the first instance they said that, well, yes, you can have your 14 days, but then it changed to, well, I'm sorry, you can't, but we need a hearing by the 27th of July. It was only when your lordship said that that might pose you some difficulty that we then had a debate about various directions. But again, what we say is that was just a dressed up attempt by my learned friend to try and show the court, to demonstrate to the court that this hearing was necessary, and we say it wasn't. It was only the only effective issue before you today was one of costs, and that could have been dealt with by a very reasonable approach by the claimant to reserve costs. And in those circumstances, as I said, in the first instance, the order should be that the claimant should pay the defendant's costs for their unreasonable conduct. But if you're not minded to give that award, your lordship, then costs ought to be reserved to the return date. Your lordship, I'm grateful for allowing me to take you through that big ream of correspondence. But if there are any further questions, your lordship, I'm going to leave my submissions there.
Thank you.
My lord, I hesitate to extend the debate on costs, but very briefly, if I may, just a few short points. Firstly, it's not correct that the claimant did not warn the defendant of cost consequences.
I'm not very interested in that element. It seems to me absolutely inevitable that anybody would be conscious that costs will be incurred unless matters are resolved.
Yeah, thank you. I mean, in essence, what we say is that the response that we received on Tuesday morning to our very straightforward request, please confirm that your client will comply, was quite remarkable. And I used the word astonishing advisedly. The defendant at that stage was plainly in breach of the order. His position was the information was due on the Sunday. We said the Saturday, but fine, we'll take it on the Sunday. By Monday, he hasn't provided it. He's in breach of the order. There's no mention of that in KBH's initial letter. The claimant said, please simply confirm you're going to comply. And the response comes back, in effect, well, we're still thinking about it. That is an extraordinary response in the circumstances. The second point is that there has been no full explanation, certainly no evidence, of what contact the defendant has had in relation to getting legal advice. We hear now from my learned friend for the very first time that the defendant had in fact spoken to other lawyers in addition to KBH and had received a certain amount of advice in relation to reserving positions as to jurisdiction and so forth, and that is why we see that in those emails. At that stage, the defendant was still saying, I haven't had legal advice, right up until really, so the first time it's revealed that there is some other input from some other unnamed law firm is in my learned friend's submissions. There clearly was legal input. He was in a position to get that advice. The advice simply being comply with the order. There's no complicated advice as to what has to be done. It's literally just providing information that he has. My learned friend says in relation to my brief for the hearing, well, it was effectively incurred too early. Well, it's totally unrealistic submission. Most of the costs are associated with my briefing. We'll come on to the quantum if you're on my side on the principle. But the idea, we get their response at 4 p.m. the day before the hearing. The idea that a brief fee would be incurred no earlier than 4 p.m. the day before a hearing is simply unrealistic. Then we have all these assertions about the defendant's means, and it's said that he's going to be stifled. There's no evidence to support that, and it's said, oh well, he has no income. Just bear in mind two short facts in relation to that unevidenced assertion from the bar. Firstly, in correspondence, the defendant has asked that his living allowance be increased to $10,300 per week. He wants to spend that much money a week. And then my learned friend feels able to say, well, he doesn't have any money. That is an astonishing submission in that context. Secondly, the evidence shows that he is the shareholder and a director of various other companies, including a software company in the DIFC, which is one of the principal reasons why we sought a freezing order there. So I just ask your lordship not to accept on submission that he lacks means or that this will cause anything to be stifled. And then finally, I deal with my learned friend's submission that my position is disingenuous. So my learned friend speaks the English very well. She will know disingenuous means dishonest. My position is neither disingenuous nor dishonest. I've never said that this hearing could not have been agreed. It could have been agreed, and I'm absolutely sure. My point was that we were not willing to agree to an adjournment in circumstances where the defendant was in default. It was important in those circumstances, certainly before KBH came online, and then in light of their responses, to get him in front of a judge and have a judge make it clear to him, regardless of any objections he had to the order, he had to comply. That was the position. That is a perfectly reasonable position to take, and indeed a necessary one. The point about timetabling and scheduling was raised simply because now we were before Your Honour, Your Lordship, then there was an opportunity to raise that issue and see whether something could be done before the end of July. So I never said we needed this hearing absent compliance. We've always said if we got the assurances that there would be compliance and the information would be provided, then this certainly could be adjourned off and dealt with on the papers, and any further timetabling issues could have been dealt with in correspondence with the court. But that's precisely my point. That's my case, which is that it is the failure to comply and then the subsequent failure to provide confirmation that the defendant would comply, which has led to all this money being wasted. The money being my brief fee, which is £15,000, and which is $18,000 plus about $10,000 from my law firm, my instructing solicitors. So it's a $28,000 bill at this point. That's all I was going to say in response, unless there's anything else I can help with.
Thank you very much. The court.
Your Lordship, may I just make a couple of points in reply?
How many more goes do you want?
Well, I'm entitled to reply, Your Lordship, and may I?
No, you're not.
No, you're not. You're not actually entitled to reply, but you can have 2 sentences.
2 sentences starting with a paragraph, maybe? Your
Come
Lordship,
on.
I'll be very,
Let's
very quick. My learned friend has said about I'm making submissions on behalf of the defendant without any evidence, and your Lordship, that's absolutely right, and therefore I invite you to reserve the issue of costs until you hear evidence. And of course we will be filing responsive evidence, and all of this matters can be articulated and set out in that responsive evidence as to when and what and how and any legal advice that the defendant may or may not have obtained. And so we invite you to, in fact, take on the suggestion of my learned friend, firstly. Secondly, in terms of the increase of 10,300, my Lordship, I have made a submission that increase.
I'm not dealing with quantum yet.
Grateful. Your Lordship, in terms of disingenuous, I beg to differ with my learned friend's interpretation of disingenuous. By no means was I alleging that my learned friend is not dishonest. In fact, disingenuous is not candid or sincere. That's the definition that has come up with disingenuous, and therefore I leave that there. In terms of
it's not a good thing to be saying of another counsel unless there's I mean it's not an expression you use lightly. I don't think it's one that should have been used, whatever nuance you put on it.
Your Lordship, in which case then I retract that, and perhaps I say that my learned friend was trying to dress up the reason for this hearing, and I'll leave that there. Now, in terms of my learned friend saying that actually the reason why they wanted this hearing to make it clear to the defendant that he had to comply. The claimant said that he was going to comply. He said it first thing in the morning when he received the letter. He said it on the 1st of July that he was complying. And therefore, Your Lordship, it didn't need this hearing for Your Lordship to say you must comply, because he had every intention to comply. And so, Your Lordship, again, we made the submission that firstly, the defendant should get its costs, and if not, then obviously the cost should be reserved, Your Lordship. And I leave it there, and thank you so much.
Thank you. Well, I'm against you on that, Ms. Ahmed. The court does not consider that the defendant's conduct was satisfactory in response to the injunction, which was granted on the 28th of June, and on the face of the evidence currently before the court was served personally on him. It's obvious to anyone in such circumstances that unless they comply and that in the absence of an agreement, there will be a further hearing and that costs will be involved in that. It's also obvious that a hearing will go ahead where there is a breach of the order, absent some agreement between the parties to the contrary. In my judgment, a hearing would necessarily be bound to go ahead, absent a timely compliance with the order for disclosure of assets over 100,000 dirhams, or at least an assurance of compliance that could be relied on. The immediate response of the defendant was to say that he would comply with the order, but then the reservation was immediately thereafter introduced that this was subject to the taking of legal advice. Now, of course, a litigant in person is entitled to take legal advice, but any such advice from any competent lawyer when faced with this order would be to comply with the terms of the order for immediate disclosure, making all necessary reservations with regard to any issues which were matters which could potentially be raised in objection to the order, in objection to the court's jurisdiction, or matters of that kind. In fact, what appears to have happened is that the defendant already had lawyers engaged who were acting for him in onshore Dubai, who were also registered to act in the DIFC. It is hard to imagine he did not take advice from them and receive advice of that kind. It is, however, said that he was in contact with a number of other lawyers and obtained some input, the details of which are unknown, save as partially revealed by Ms. Ahmed today. At all events, he was in contact with KBH on Friday and was able to discuss the matter with them on the Sunday. Taking the matter at its lowest from the court's point of view, it appears to me that by the end of Monday, the 4th of July, the defendant should plainly have given disclosure of assets of over 100,000 dirhams in compliance with the order, whilst reserving his rights to challenge the order, whether on grounds of absence of jurisdiction or anything else. At the very least, it might be said that there should have been an assurance of compliance, but I'm not even persuaded that that's really the case. The number of assets that have actually been disclosed since that date on the 5th of July show that the matter was easily capable of being dealt with on the Monday, and in my judgment should have been. In those circumstances, it seems to me inevitable that the hearing was going to go ahead, even when the last-minute disclosure was given. Costs were going to be incurred, and it would be necessary to come to this court to iron out the issues which have, in fact, taken us an hour and a quarter or more this morning. So in those circumstances, costs were necessarily incurred by the plaintiffs, and the plaintiffs should be entitled to them. I'm confident that if there had been disclosure and then had been sensible discussion between the parties, the costs would not have been necessary, because an agreement would have been reached as to the dates for further disclosure to be made and for the hearing. What the plaintiff really wanted was to be clear that the current position was preserved pending determination of any challenge. That we have achieved by the timetable that has been agreed, and that could have been achieved without the assistance of the court if there had been timely compliance. So in those circumstances, the plaintiffs are entitled to their reasonable costs, which I will now assess.
Thank you, my lord. The cost schedule you will find online. You have to click to it. It's in the final page of the bundle on page G360.
Yeah.
And there's a hyperlink at the top.
Okay.
If your lordship clicks on that,
Oh, here we are. Yeah.
you'll get an Excel spreadsheet which breaks it down by, there's various different tabs across the bottom which break down the sum. I'm going to just tell you a little bit about it, but not too much. If you've got to that summary,
yes,
you'll see the expenses and disbursements amount to 19,150. That there is, I'm afraid, a tab, and it's all the way across to the right of expenses and disbursements. But I can give you the punchline, which is that they include my brief fee for today, which is £15,000, and there's £1,000 DIFC court fee for the hearing, as I understand it. So that's the bulk of it.
where are the disbursements?
I'm so sorry. That is the last. If you see the tabs at the bottom.
Other work? No.
No, it continues. So you may need to drag
right,
a
plus,
slider.
right.
I'm afraid there's a lot of them. I think it's a standard form that's used, but the final one is disbursements. Yes, I'm sorry.
And on.
It does go on and on. Not all of them are used in this occasion.
But I've gone too far.
I can just tell you what it says. I mean, it says £1,000. $1,000 for a DIFC court fee.
Yes.
And £15,000 for my brief turns into 18,150, and that is why when you go back to the summary, you get 19,150.
Okay.
The balance is about $9,400, which consists of quite a bit of letter writing, it has to be said, and work on documents. There's a bit of work to do as well to upload things onto the case lines, filing things and so forth, but there was a fair bit of correspondence back and forth. I'm not sure how much help I can give you other than to say, firstly, in relation to my brief fee, that's essentially 2 days of work. But in terms of the further sums, $9,500 is, we would say, not a vast amount to deal with as to deal with a hearing. I mean, we accept that all other costs can be reserved, but this is just the isolated amount related to this hearing. Beyond that, I'm not sure how much help I can give you on the detail.
All right, Miss Arthur.
Your Lordship, clearly you decide on the principle, so it just remains to look at the figures. Now, I haven't been able to open up the Excel spreadsheet, so I'm going off what my learned friend has told you. Essentially, his brief fee, which is around £15,000, and that's for 2 days of work. Dealing with that, firstly, we say that this is a very short hearing. It definitely didn't require 2 days of work. In terms of the work required, a skeleton argument, which essentially you've seen, it's not a lengthy or complex skeleton argument. It simply deals with updating the court about what's happened. There hasn't been any legal argument here. The hearing itself has taken 1.5 hours, and therefore we say that 2 days work is not appropriate, and therefore that should be reduced down by at least half, if not less. In terms of the lawyers' fees, the submission made by a learned friend was about $9,000 US for the various letters that have been written, and we say that that should definitely be assessed down on the basis that the letters, we say, were overly lengthy and didn't require 4 or 5 pages of writing, and effectively. We also say that this matter could have been dealt with quite easily had Malone and Friends solicitors picked up the phone and perhaps had a conversation with us, and therefore we say that that's unnecessary and it's not proportionate, and therefore that should be assessed down completely. This is a matter that could have been dealt with, we say, by 2 or 3 letters, and therefore we say 9,000 is simply not proportionate and should be assessed down. And in fact, if anything, it should be assessed down to a fraction of that, and potentially 25% of the 9,000 that's been stated. Then, of course, it's the filing fee of $1,000. I mean, that's the filing fee and that's disbursement, and I don't think that there's much to be said about that. So those are my submissions in terms of the 3 items that my learned friend has raised. As I said, I'm not able to find the Excel spreadsheet, but that's why my submission is just concentrating on 3 items that my learned friend has highlighted to you.
Just dealing with the brief fee, if I may, Your Honour, just make the point that clearly the preparation up until 4 p.m. yesterday was for continuation of the freezing orders. So I needed to be in a position to argue the whole application. That's what I was preparing for.
Yes. Well, bearing in mind Miss Ahmed's criticism and taking the usual broad brush approach, the figure I arrive at is $25,000.
Thank you, my lord. And if I can suggest that be payable within 14 days.
No, sorry, Your Lordship. Sorry, I've just been handed the statement of costs. I think it says the total is $21,000. Is that right? Am I looking at the right thing?
28,515.98.
No, I've got 21,723.48.
I think you're looking at an earlier version, are you?
Correct.
No, it says claimant's statement of costs thrown away be hearing on the 6th of July, Wednesday, the 6th of July.
Yes, it's been updated.
Right, well, I don't.
With further solicitors' costs. So you'll find it in the bundle at page G6.
If you've got the electronic bundle, Ms. Ahmed.
Yes, I have.
You can pick it up at the end. The reality is that you've picked on the points that matter, so to speak, because when you see the details, it tells you total numbers of hours in terms of solicitors' work, which is hard to challenge. The bulk of it is in the disbursements and in Mr. Montague Smith's briefing. Yeah. That's the reality.
I'm just looking at the index. G92, claimant schedule of costs, Excel. G93, G104, claimant schedule of costs thrown away. So.
Yes, there's an updated version of it at page G.
At the very bottom of the.
Oh, they emailed it. When? When you say at the very bottom, what page number? Because the last page I have is G252.
On case lines. It was sent by email.
Are you on case lines?
I am on case lines, yes. I am on case lines.
I've lost it now, but it's G28, isn't it, Mr. Montague Smith?
27.
27.
Tab 27. It may be just unique. Well, I don't know whether you've had that case lines open. If you have for a while, you may need to refresh it. That's all. It's in the master bundle. The increase is I think simply because up until the time that the original cost schedule was sent, only a couple of $1,000s had been incurred, and then this is an update to include the cost of the hearing, really, and the bits that happens to.
It's an increase of about 7,000. So I'm just wondering, the one that I've got in front of me says 21,000, and then the one that you're looking at, and I still haven't been able to find it, I'm afraid, is around 28,000. So that's an increase of about $7,000. When this was served, I think yesterday at around 4 o'clock. So is it the case that there was an extra letter or two written, and that has incurred costs of nearly 7,000?
And lawyers have had to attend the hearing, and there have been discussions behind the scenes and advice given and all the rest. But I mean, I think I don't know what your lordship wants to do about this. I understood you made a decision. Oh, it's I'm just told actually that the first spreadsheet didn't capture any of the time from yesterday from the solicitors.
Well, that's what I had suspected, but
Well, Your Lordship, I still don't have the updated schedule of costs, but be that as it may, you've heard my submissions and the points made by my learned friend.
yeah. Well, I've made my decision, so it's 25,000 in the round. Thank you very much.
Thank you, my lord. And I was going to suggest within 14 days in the usual way.
Well, Your Lordship, may I?
I was,
Sorry.
yeah, go on. You say what you want to say.
Your Lordship, I was going to seek more time, given the submissions made about the circumstances of the defendant. I know the usual order is 14 days, but I'd certainly seek, I'd seek 28 days.
Yeah, I'm happy to go with 28 days. He may have to sell another Rolex. All right. Let's leave it there then. If there is any insurmountable problem about the 8th of September, you'll have to contact the court and we'll revisit the thing. But otherwise, we're working on the basis of the timetable set. And will you produce a draft order, please, Mr. Montague-Smith?
Yes, Lord.
And agree that with Ms. Ahmed, particularly on the relevant wording that's been the subject of dispute about continuation and so on and so forth. But to be plain that the order continues in effect with the rights of the defendant to challenge it on the timetable we've set out.
Thank you.
We agree that, and once it's agreed, send it to the registry and I can approve it.
Certainly. Thank you very much.
Very good. All right. Thank you very much, both of you.
Thank you.
Thank you, my lord.
If you leave, I'll have a quick word with the associate.
Thank you.